164-661. This is Affiliated Diagnostics of Coleman versus City of Detroit. The matter is before the court after having been referred for mediation. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. James Lowe on behalf of the plaintiff. My P number is 63110.
Good morning to you, Mr. Lowe, and Happy New Year to you.
To you as well.
For the City of Detroit, you may at this time.
Good morning and Happy New Year, Your Honor. Alfred Ashew on behalf of the City of Detroit, P82536.
Thank you, Mr. Ashew, and the same to you, sir. All right, so I know that we've engaged in the attempt here. Somebody update me at this time.
I guess I'll go, Your Honor. So there was apparently a mediation that was scheduled. Somehow it wasn't in our calendar, but I did get a call from the mediation center. So I did appear, I believe it was last Thursday. I was trying to get a hold of what I thought was counsel on the case, which was Crystal Olmstead. Turns out it was Mr. Ashew, but it sounds like they had confusion about the case. So, and I'm not sure exactly what happened on their end, but they didn't end up appearing. But I have so many cases with that office that I wouldn't hold that against them.
So the mediation tribunal did not take any action. Is that correct?
Yeah, because I was the only one that appeared. There was there with a retired lawyer who was serving as the mediator. It sounds like if we can go back, I think it might be productive.
All right. Did you get a return date, or I'm not so lucky?
I think we have to take some affirmative action probably to get that date.
All right. Do I need to reissue the order that I sent out, or can you get this done in the next 30 days or so?
I think we can get it done in the next 30.
Yeah, and I think actually it might help if you send out that order again to just to trigger the steps on their action.
All right. I will reissue the order. I'll get that out today, and I'm going to go ahead and set a control date on this matter, and we'll bring it back on the 10th of February. Looking at 210 at 9:30.
That works for me, Your Honor.
Yep, works for me as well, Your Honor. Thank you.
And I'll get that the reissuance of the order that will be done today.
Thank you, Your Honor.
Thank you, Your Honor.
Somebody chat me an email address, and I'll send it by way of email today to at least one of you. They just make sure the other side.
I will send that now, Your Honor, on my end.
Yep, I'll send mine.
The court does call case number 21160-888. This is Carson versus Oliver Management, and Arnold Oliver and Evelyn Oliver. Today is the date and time set for a hearing in this matter. Trying to see what the court previously scheduled this matter for a few things. Also, the court did issue an order for a more definite statement. Your appearance for Carson, please.
Here I am.
All right, thank you. You're represented by Mr. Hill, Ryan Hill?
No, I don't have an attorney. They was changing things, so I don't know.
All right, I don't see where they withdrew from your case. Did they tell you that they were doing that?
I never had an attorney, so I don't even know where he came from. I never talked to anyone.
Okay, no problem. I just see that name attached here. Okay, very well.
They put it. It was a mistake downtown, and they actually changed it. They changed it down there.
All right, thank you very much, man. For the defendant in this matter, Oliver Management et al.
Yes, Your Honor. Attorney Jessica Warfield, P85391 on behalf of defendant, standing in for Attorney Ryan Hill.
All right, thank you. So you represent the defendants in this matter, is that correct?
Correct, Your Honor. Yes, we were recently retained on this matter. So if I could, Your Honor, oblige the court to give us a little bit more time for discovery, so we can just send our request out to the defendant as well.
Very well. So I saw that there was I granted an order for a more definite statement on an earlier date that was to be taken care of by the 11th. I take it that you received something along those lines. Is that correct?
We have met up with Mr. Sagati's office and we do have the documentation here. Yes, Your Honor.
All right, very well. So how much time are you asking for as it relates to discovery regarding this matter, ma'am?
Your Honor, if we can get 60 more days, I believe that would be extremely helpful for us.
All right, so I granted a period of discovery, but I understand that you're just coming to this case. And that was back in October. And I granted discovery for the 10th of January. And then set the hearing on for today's date. Ms. Carson, you understand what's being requested here, ma'am?
Yeah.
All right, so I'm gonna extend the right of the respective parties to request documents and information under the authority of the court. And I'm going to extend the opportunity to do so through the month of February. It's going to actually grant about a little less than the 60 days requested. So I'm going to set this matter on for the 28th of February, be the next action date of this matter, February 28th, and that's going to be at 9:30 a.m. I will set that for a final pretrial conference. I will also indicate that any motions that either party wish for the court to hear on that date, you file a motion with this court, so long as you give the other party at least 7 days to respond to the document. The court will hear the motion on that date. Whether it is a dispositive motion or a non-dispositive matter, if you file a motion with me and set it for hearing on the 28th, as long as you allow the other party at least 7 days to respond to that motion, I will hear it on the 28th.
Your Honor, can I say something?
Yes, you can.
Yes, I was just trying to get it over with. I've been going through so much already, and it's just been a whole big old total, like it's a frustration. And I've been at the point of really ready to just leave here because it's so much going on, from the house down to my mom getting sick down to me just going into a nervous breakdown over just keep having to go back and forth with this issue.
Yeah, I'm very saddened to hear of your mother being ill. Those are significant things in this whole season of illness. When you file a lawsuit or when somebody sues you, that's a big deal. And it takes time for things like that to get litigated based upon the court.
Okay.
And so that's why it involves coming back and so on and so forth, because there's just a process involved when there's a lawsuit involved. That's what's going on. I try to be diligent to move it along as quickly and as strategically as I can. But,
Okay, I understand.
so February the 28th will be the next hearing date on this matter. It's going to be at 9:30 a.m. And you'll get another order from me in this regard as well.
Thank you so much, Your Honor.
Thank you. Good day to both of you.
Same to you as well. Thank you.
All right, the court calls case number 21-166029. Strike that 92 is the last two digits. That would be Roberts Orthopedic Services PLLC versus City of Detroit. The matter is before the court, set on for a hearing. Looks like the issues have become joined in this matter. For the plaintiff in this matter, your appearance at this time, please.
Good morning, Your Honor. Jean Charbonneau, P43057, on behalf of Roberts Orthopedic Services.
Thank you, Ms. Charbonneau. Good morning to you, ma'am. For the defendant, City of Detroit at this time, your appearance at this time, sir.
Yes, good morning, Your Honor. Joel Ashton appearing for the city, P number 47039.
All right, thank you. Thank you, Mr. Ashton. Good morning to you, sir.
Morning.
I have seen or noted that that you filed a response in affirmative defenses in this matter. I've also seen plaintiffs reply to the same. So it looks like there is some discovery that might be needed in this matter. Madam Counsel.
Yes, Your Honor, we actually have been in communication back and forth as well. And we are set to facilitate with the underlying case actually this week. We have shared facilitation summaries as well. So if everything goes well, we're hoping that the facilitation will be successful.
All right,
That's
very well.
correct.
Sounds reasonable, Mr. Ashton. So why don't I set this out maybe 2-3 weeks for review?
Perfect.
See where that time. All right, so I'll go ahead now and set a review date. Let's take a look at it. In fact, let's do the 27th of January. 127.
You could, but you got about 30 cases.
And I do have a bunch of cases that day, so you'll just be coming in for review. So I'm going to stick you right in there at 10 o'clock a.m. And if for some reason it seems like you're deep in a line or something, then just say, Judge, we're here for that review, and I'll pull you right up so we can get you in.
Okay. Thank you, Your Honor.
Got it worked out, then we'll know that. If you haven't, then we'll just set it up real quick on some kind of calendar. All right.
Very good.
127, at 10 o'clock.
Hey, thank you, Your Honor. Thank you. Have a great day.
Thank you.
All right, the court is called in case number 21-161275. This is Portfolio Recovery Associates LLC versus Charday Leverett. The matter is before the court, set on for hearing. Looks like there was a motion for summary disposition that was filed previously in this matter. Your appearance for the plaintiff in this matter, please.
Good morning, Judge Coleman, Cezanne Barda, P65425 on behalf of the plaintiff.
Thank you, Mr. Barber, and good morning to you. I'm looking for Ms. Everett or Leverett, I'm sorry, or her counsel. Say something if you do.
I'm here. This is Charday Leverett.
All right, thank you, Ms. Leverett, and good morning to you, ma'am.
Good
All
morning.
right, Mr. Barda, what's going on here, sir? I have a shell of a file here for some reason. Go ahead, tell me, sir.
Your Honor, I believe this was a matter where we filed suit. There's a proof of service in the file. A judgment was entered, but then Ms. Leverett filed an answer with the court stating that she did not live at that address and that she received the complaint from a tenant at a different address. I think the court unilaterally sent out an order setting that judgment aside because an answer was filed. So I believe she's been availed of the court. I believe this notice still went out to that address that she says she doesn't live at. So obviously, I'm not saying she lives there, but she's obviously receiving it from whoever is living there. So I think the notice today states that it's to talk about the proof of service. However, I believe because she filed an answer, this should probably be treated as a pretrial. I don't know if the court wishes to schedule a motion for summary. I don't know if Ms. Leverett wants to call my office and try to resolve it. I'm not really sure what the court wishes to do today with this hearing.
Gotcha. Regarding the notice, the last notice from the court went out to an address on Britain. The initial address in this matter appears to be an address on Newcastle. So, the court's most recent notice was sent to the Britain address. Ms. Leverett, you live in Britain?
I'm sorry, could you repeat that? It was breaking up, Your Honor.
Not a problem. You live at the address on Britain Street, is that correct?
No, like I said, I haven't lived there since I was a teenager.
Gotcha. You live at the Newcastle address now?
Yes, for the last 3.5 years.
All right. So the notice that I recently sent out was sent to the Britain address so that you received the notice some kind of way. Somebody gave it to you. Is that what it is?
No, the most recent notice, because we had a previous court date, and you had me enter my current address in the chat. So the most recent notice you sent out, it came to my Newcastle address.
All right. The notice I have in front of me is directed to the Britain address, but I'm glad that we've got that straightened out as it relates to the Newcastle address. All right. Very well. So the issue in this case at this point is whether the court set a scheduling order, set the matter up for a motion for summary disposition. The principal issue being whether or not there is a meaningful dispute as to whether or not there is a underlying obligation. If there is an underlying obligation, there may be room for the parties to discuss how to resolve that. Otherwise, I think what plaintiff's counsel is looking for is to set a motion before the court, asking the court to enter judgment based upon the documents regarding the obligation. You understand what I'm saying, Ms. Leverett?
Not really. If you could elaborate on that a little bit.
All right, so the nature of this case, I don't have a complete file, but the nature of this case obviously is that the plaintiff portfolio has sued, indicating that there is some money that's owed.
Okay.
If there is not a real significant dispute, whether or not that's true, then the parties may want to engage in a discussion to see if they can arrive at an agreement as to what amount and how that amount is going to be paid. Otherwise, I set aside a judgment, but if there's not a real contested issue regarding whether or not there's an obligation, the likelihood is that that judgment would ultimately be entered again, if not by default, by some type of motion for summary disposition to try and get the order back in place.
Okay.
So the two propositions I'm putting out there, and both parties know this case better than I do, it's just filed in front of me. Obviously, if motions are filed, then the court gets a closer look. But if on both sides it is believed that there is some obligation that exists here, then it might be worthwhile to talk about ways to resolve that, whether or not there can be an agreement as to a particular amount, and whether there can be an agreement as to how that amount might be paid over time, et cetera, et cetera. So that's one part. The other part is just to go forward with contesting it. If a motion is filed and there is a solid basis behind the motion, then the court would likely grant the motion. That would mean the judgment would be entered, and it will be entered without any negotiations. So those are kind of the ways to weigh this right now. What I would like to see happen, if the parties believe that there might be some obligation here, I'd like to see the parties go into a breakout room and talk about that and see if an offer can be made, a number can be reached, wherein the parties could reach a resolution, and then talk about whether that can be paid all at once, or the parties could agree to a payment plan, or the defendant could ask the court for a particular amount to be paid on a monthly or bi-monthly basis. All right, Mr. Barber, you understand what I'm saying, correct, sir?
Correct.
Ms. Leverett, you understand the parameters that the court has set for
Yes.
this discussion?
Yes, sir.
Why don't I take a moment to put the two of you in a breakout room just to see if we can talk about this a bit. You come
Okay.
back and join out, take a look at things and figure out if we can go forward with this.
Thank you.
Okay, so you're gonna get a notification from me, Ms. Leverett, to breakout room number 1, and there it is. And counsel, I'm sending you the same, sir. All right, so just click into that breakout room, and then you'll get a chance to talk privately.
Okay, thank you.
All right, the court is calling case number 21-163-282. This is Van Dyke Spine Rehab Center versus City of Detroit. The matter is before the court after the filing of a responsive pleading and answer has been filed in demand for jury. The issues are joined. Your appearance for Van Dyke Spine, please.
Sure. Good morning, Your Honor. May it please the court, Fadi Toma on behalf of the plaintiff.
All right, Mr. Toma, if you will, your P number, sir.
Sure, 63746.
All right, thank you, Mr. Toma, and good morning to you, sir.
Good to you.
For the defendant, City of Detroit, your appearance at this time, please.
Good morning, Your Honor. Chelsea Grimaldi on behalf of the city, P85585.
Thank you, Mr. Molly, and good morning to you as well, ma'am. So somebody update me, has there been any initial disclosures? How far have you gotten along with this matter? Go right ahead if you will. Either one.
Your Honor, I don't. Sure, I don't think anything has been done in the sense of discovery. This is our first pretrial. I would just request that we have perhaps a short discovery period of maybe 90 days or so to exchange some written discovery, and just take it from there, Your Honor.
Mr. Kamali, your thoughts on that, ma'am? About the same?
Oh, that sounds great, Your Honor.
All right, so what I will do at this point is set it up on a 60-day discovery order. I'll allow open discovery, and that will continue through the date of the next hearing. I'm going to go ahead and set that the next hearing in the month of March. And
March. Well, the first week of March. Okay, March the 4th. The second week, okay, the 7th. March 7th. 7th.
March 9th is going to be the date on this matter, 3/9/21, and it's going to be at 9:30 a.m. I will allow discovery through that date, and I'll set a pretrial hearing on that date. Obviously, 60 days gets by quickly. I anticipate the parties will move this along. If for some reason there's something still hanging out there, I'll be able to tighten it up when we get back before we on the 9th of March. I'll also indicate to both sides that my order is going to provide that you may file motions and set your motion on for hearing on the 9th of March. And that motion can be motions could be dispositive or non-dispositive. I'm shortening the time that's normally allowed by court rules, so long as you allow the other side to have at least 7 days to respond to your motion. I will hear it on the 9th of March. So you can use that as that date. If something comes up where you feel that you got enough to file a motion in this matter, then go ahead and file it, and don't think that you got to wait for 28 days or so on and so forth. Just make sure that you give the other side at least 7 days to respond to your motion, and set it for hearing on the 9th. I will hear it that day. All right, anything else at this time?
No, fair enough. Thank you, Your Honor.
Thank you, Your Honor.
Thank you. I wish both sides well. I'll see you on the 9th of March, if not so.
Thank you.
Thank
Have a
you.
good day.
Thank you.
All right, the court at this time calls case number. That's what he has.
Oh, okay.
This piece.
Oh, okay. All right.
And the notice has that written address on it, but she obviously got it. So we have on the register of action. So
Okay.
should.
All right. Change.
Ms. Finch, you were good there?
Morning, Judge. Yep, I'm good. How are you?
I'm good. Good to see you.
Nice to see you.
I have a Christmas gift for you, but you're probably gonna get that gift sometime in March.
Oh, wait a minute. What you say, Judge?
I said, I've got a Christmas gift for you that's been here. I said, you probably gonna get that sometime in March or something.
Oh my God. I'll have to come down there and get it. I can't wait that long.
I should have told you nothing.
Yeah, you should have told me. A gift. Thank you. Thank you very much.
Welcome back, Mr. Barton, Ms. Everett. I found the file while the two of you were out, and the chuckle in it is that it was under the little package that I had. So as soon as I picked that package up, there was the complete file. So I've got that stuff. All right, Mr. Barton, update me on things at this point, sir.
Your Honor, I made an offer, and Ms. Leverett countered with a number that's below my authority. So I just have to get authority from my client. So I'm going to submit that offer to my client, and I will reach back out to her hopefully in the next 2 or 3 days. In the meantime, I think we just need a control date of probably a motion for summary disposition I don't know if you want to push that out 30 or 60 days. And hopefully we can get something resolved into the court prior to our next hearing date.
All right, sounds good to me. It makes sense. Sounds like Ms. Leverett is playing lawyer a little bit. Offer, so forth. And I'm being facetious there, but that's what going into the breakout room is about, and take an opportunity to try to talk about it, see if you might be able to bridge your differences. So what I'm going to do is I'll go ahead. I'm going to set it 30 days out and hope that it resolves. And if it doesn't, then I will allow for the filing of a motion to be heard on the date that I'm going to give. That date is going to be February.
Your Honor, if I,
10th. Hold on 1 second. February 10th at 9:45. 2/10, 9:45. Ms. Leverett, you next time.
yes, I just wanted to request, if possible, if we could, instead of the 30, I mean, I'm definitely waiting on, follow up from Attorney Barta, but if possible, if we had to come to a hearing date, is it possible that we could schedule it out the 60 days? And I just say that because I'm in a probationary period at work, and so they kind of gave me a little, a little pushback about the court date today. And so they said anything else, if we can push it out beyond my probationary period, which is March 1st, that would work better for me, just to, ensure I'm not jeopardizing my employment.
We don't want you to.
I mean, I intend we would probably work it out before then, but if we had to do a date, if possible.
All right. I don't like giving extra time. Okay. Mr. Carter, I'll at defendant's request, I'll go ahead and set it in the month of March. And what happens, of course, if you get it resolved, then you won't even have to come for that date. Just paperwork will be submitted in court. Sign off on paperwork. So I'll go ahead and set it for. Go ahead and set it for March the 3rd. Does that work for you, ma'am?
Yes, that should be fine.
All right, March 3rd, 2022, and that's going to be at 9:45. Any motions that might be filed, dispositive or otherwise, can be set for hearing on that date. The only requirement is to give at least 14 days. In this instance, I'll require 14 days opportunity for the other party to respond. 14 days for the other side to respond.
Okay. Thank you, Your Honor.
All right, that is my word, and I'll see the two of you soon, hopefully, but hopefully it works out and get that. Okay. Mr. Barner, I'm sure I'll see you because there's.
That is correct.
Another case that you filed somewhere. It does not involve Ms. Leverett. I'm sure there's another one somewhere.
Thank you.
Have a great day.
Have a great day to the two of you.
Alrighty.
All right, you as well.
Bye.